as I'm hearing the evidence, the only two issues have nothing to do with the facts that would give rise, or that would support this board reversing the decision of termination in this case. What I'm hearing is that Mr. Neal now takes the position that he didn't know what he was supposed to do on this retesting of the split sample, and that somehow the county is responsible, not him, because they didn't train somebody pursuant to about a federal regulation. Well, the facts are undisputed here, and it doesn't give me any pleasure to speak negatively about Mr. Neal. And it doesn't give me any pleasure to see his termination decision affirmed by this board. But the facts are that Augusta has zero tolerance policy for all of its employees, and especially its safety-sensitive employees. And there can't be any more of a safety-sensitive employee than a firefighter. And you don't need me to argue to you the dangers and the risks and the problems with a firefighter at work on drugs. Mr. Neal was given more than due process. He was given every due process available to him over and above what the Constitution or what any law would require. It's not going to make any of us sleep any better tonight, but it was an appropriate employment decision for the city of Augusta to make, and it would be appropriate for this board to affirm that decision and uphold the decision to terminate. Unfortunately, to terminate Mr. Neal for this random drug test result.
There was no negative job performance whatsoever. That's circumstantial evidence showing that he was not using drugs. Then you have a test that the sample's taken on the 16th, and they won't recognize the fact that scientifically, apparently, the split sample can be used a whole year for a retest. And that wasn't offered or made available or mentioned during the first go-around. Neither hand knew what was going on as to who had clear responsibility to sit down with the employee and say, this is how you get the sample for a retest, or this is how it's done. The county says the MRO should have done it. The MRO had no training about how to inform the employee about how to meaningfully protect himself. And so while you have one test that is obviously positive, then there is, and it's required, but you have an alternative means to do a second test to protect yourself, because sometimes things go wrong. So throughout the first process, the first administrative hearing, there was a misconstruction of the 72-hour thing and a total disregard of that second sample as being a means by which you could have cleared yourself. So you don't have a raft of people flunking the drug test and then saying the procedure's bad here and there. So it isn't that if you put him back to work because this test is bad here, you're going to have people who say, yeah, we can go out and smoke marijuana and get away with it. That's not realistic to think that that's what would happen if you were to say he should get his job back. I think that from what you've heard from me today, you can think of ways to recommend to the commission that the test and the retest and protection for the employees could be improved. There's no question about that. And that a lot of the questions that caused us to have to do all this could be cleared up, which would be good for everybody.